You guys ready? You guys ready? Right. We are not, I'm not live on the speakers. This is for the benefit of that camera back there. And the reason I'm not clipped this thing to me is because this is going to be interactive. You guys know Nebraska law. You know how to solve these problems within Nebraska. So we're going to do a Nebraska deal here. I'm going to be passing the microphone around for the most part. I want you guys to answer the questions. We're going to work you a while now. I'm tired. And I was dodging some imaginary bottles up there. But case one scenario, if you've not had a chance to read it, let's take a look at it very quickly. I don't want to read these to you. Some of them are long, but please take the time to read it yourself very quickly if you have not already done so. Okay, this is particularly interesting given where Nebraska is going right now, because we had some discussion about this in the pre-summit workshop yesterday. And the question was raised whether when privatization comes in, does that mean that these conferences are going away? And one person suggested that these are pretty safe, but some other programs will be going away. So this is a situation where the question ultimately here is the agency, at the protective custody hearing, you order a family group conference be arranged and paid for by the department. After the hearing, you learn that they will not authorize it because they don't have any money. All right, and this one may be real, because this is actually the one this is the family group conferencing that we understand may be at risk under this new system in Nebraska. So who wants to sit on the bench for a minute and solve this problem? This is Nebraska, not Georgia, so you guys need to talk among yourselves on how to solve the problem. Who's going to let it go? All right, so nobody's going to let it go. That means you're going to solve the problem. How are you going to solve it? All right, we've got to give you the mic because we've got to get you on this thing.
Solution, but what's happened in various jurisdictions is a subpoena goes out requesting the head of the department and other people to show up for a hearing, and you get somebody's attention, and frequently between setting of the hearing and the actual hearing, they find money for it. Fair enough?
Fair enough. And we would do that with what's called a show cause. I'm not sure how you guys would do it. It's not a contempt action. It would be to show cause why this service cannot be provided. And I used the example yesterday of, I did that early on in my time on the bench, and the issue was whether or not they could do a psychological, and I subpoenaed everyone that had check signing authority. That's one way to do it. What are some other ways to do it? Let's talk about some off the bench ways to do it, perhaps. Now initially we're trying to solve this problem in this case, but this means also if they don't have money for this one, they don't have money for the one next week either. So it's both an individual case problem and a systemic problem. So how are you going to solve the problem off the bench?
One of the first things I'd want to find out is how much is it going to cost? I mean, what kind of cost are we looking here? I'd talk with the mediation people. You know, we got anybody that still has hours that they need to donate, or is there going to be cost for that? We have a bunch of transportation costs. You know, how many dollars are we actually talking about here that we can't put this together? Because mostly it's just getting people together at the same place and getting them working on it. So that'd be one of my first steps.
Any other comments?
Well, you can always do what you've been suggesting and just say, okay, here's your choice. We're going to set it for hearing on this date, and we're going to decide whether or not you've done reasonable efforts or not because you're ignoring my order, and I may just throw your 4E funds to the wind.
That would be one way to do it. And one thing you might want to do if you take that approach is ask for a copy of the state plan to see to what extent they provided for this service in the case plan. And if in the state plan, not the case plan, in the state plan, if you have a history of requiring X number of these sorts of services each year, and they have provided for X minus 30%, then raise the question of whether the state plan is adequate, whether they've really made reasonable efforts to make the services generally available around the state.
Well, in Winnebago, we have just a limited number of turnips to squeeze blood out of in the first place. So, in a circumstance like this, we've got what I would first do before looking for a fight is to talk to the people that are doing our mediation already and see what options we have to do something like a family group conference, if not something that is exactly like that, something that would accomplish the same goal. You know, in a circumstance like this, if you can find a way to use the resources you have without needing the extra funds, I think that would certainly be the first place I would look.
That's a good solution, particularly in the short term. I know before, of course, it's now required under the Family Connections Act. I don't know if Nebraska has adopted that piece of it yet. But these family team meetings are now required under that act. And we were doing those before the act. We were doing those before we had paid facilitators. We were doing something like that. So certainly in the short term, if you're close to the end of the budget cycle, there's no reason not to do the next best thing. We can't just not do anything. And by this point, you may have some people within the department that are experienced enough to lead that meeting. Maybe not, but you may have. The other would be to lean on the providers to help bridge the gap until we can get to another fiscal year. In the meantime, try to build more resources into the next year's budget. Be a way to do it.
I just have a question on, you said off the bench. Ethically, I have a question about contacting individuals or doing different things. Talk to me about that, what you do with regard to that.
I'm going to talk about it a little bit, then I'm going to ask probably Doug, who teaches on these issues for the National Council and also knows Nebraska law. Is, you know, my view generally is as long as I'm not dealing with an individual child and an individual case, I can talk to service providers about the need. Now, I can't go talk to a service provider, certainly, and lean on them to provide services for free. I think that's totally inappropriate for me to do that. Certainly, I can talk to my county director and express to her the concerns about compliance with ASPA and with state law as well if these services aren't delivered. And she can use that to go talk to the service providers and say, this judge is on us. He's threatening to cost us some federal money because we're not providing these services. Can you help us out? But I can't talk to them about individual cases. I can't use the position of my office to get any provider to provide any service at all, but certainly at below cost. It'd be inappropriate.
So you kind of deliver messages through a third party then is what I'm getting, and then they do that for you? Is that kind of how you?
Well, they don't do it for me. Because I wouldn't want to say that. I mean, I'm not doing it for that purpose. I would make the county director aware of the consequences of the failure to provide this service, money or no money, and suggest to her that she might could find another way to solve the problem. Now, again, I have no problem, of my understanding of the rules in Georgia, with doing what we did last September when she and I together brought these service providers in. We explained to them ASPA time frames and our responsibilities to provide reasonable efforts and provide these services timely, and the problem we were having doing that, and suggested a model to them that we thought would work systemically, not an individual case, and just ask who's interested in providing that service. We actually had several that were interested in doing it. Our list was narrowed considerably because, as I mentioned yesterday, we had to find someone that was acceptable both for the dependency side of our court and for the delinquency side of our court, that did good evaluations for both adults and children to make our system work. And I think that's totally appropriate to do that. I wasn't leaning on anybody. I didn't ask them to do anything on the cheap. Quite the contrary. You know, I was there to lend the county's budget where necessary to ensure funding, not to ask them to do something cheap. Doug, do you want to speak to that in terms of Nebraska?
And I think the judge's concern probably is talking about an individual case, talking with a person in isolation that might be an ex parte communication. And so I think that broader way is to do it. And we've done it with our court team meeting, and it kind of came in a backwards way. Our department administrator kind of announced where they were at with the contract situation. And we'd heard some talk about such, and it's kind of after the fact, after they work out the contract, they ask us for our input. And so we kind of took it from the point of view, look, 80% of our cases are mental health substance abuse. We need timely avowals, timely services. You know, we know what we're dealing with. And so as long as services are meeting that, you'll have your positive reasonable efforts findings. But then we were told later through another source that these providers, when they come to court, are not supposed to speak, that their reports are not to go to the court, that everything comes through the department. And the only way that that would change is if the judge decides to ask that provider who will be there, do you have anything you want to say? Or we say, is there, you're doing this work, if you feel comfortable, you might say, is there a report on this from the provider who's been doing the actual hands-on work versus someone's once removed interpretation in summary fashion. So we're going to have some meetings because we expressed to the administrator our concerns if that's how it's going to go down, that we always want the best evidence. And so they say they're willing to talk to us, so we're setting up some meetings to visit about those issues, just as a systems issue, not particular cases.
We talked a little bit yesterday about our stakeholder meetings, and that we hold every month, and then quarterly we have a larger group. And quarterly, all of our stakeholders that provide services to the dependency side of the court are invited. They very seldom come. We have an understanding with them that if we're going to be discussing an issue that specifically relates to service providers, we let them know about that, and then some of them show up for that meeting. And that way it does not waste a lot of their time, but they're included in the process. And again, if we're pretty inclusive of the things that we do, I think we run into far fewer ethical problems. So, any other comments on this first scenario? Yes, sir.
You mentioned earlier that one of these things that suggests if they actually don't have a way of funding it, you turn it into one of these cure hearings. And how long can you prolong that process before that in itself becomes an unreasonable effort? In other words, you've defined a need for the child. What's your time frame? Has anyone defined that?
Yeah, that's a good question. I've been told on different occasions that there is a regulation related to that I have not been able to find. And I've been told that you have to enter an order curing it within, I've been told 30 days, I've been told 60 days. I think it has to be a relatively short period of time. So I do 30 days. I set a hearing down within 30 days to review progress on providing that service. And that's generally a reasonable time. Because if you get there, let's say you set it for 29 days out, 25 days out, whatever, and you get to that point, and now the service may not be provided, but there's a solution has been made and the service is in place to be provided in a reasonable future, then you can go ahead and enter a reasonable efforts, positive reasonable efforts finding. I think we have to be reasonable too in our approach to this. But to do that, we've got to understand the problem. We've got to understand what's involved in solving the problem, and then set a time frame that's consistent with that. Our goal is not to deny services, dollars. That's not our goal. Our goal is to do everything we can to maximize services. That's another area where you can really work too, to encourage your county directors to have high penetration rates in terms of the money that they can draw down from sources. That's a big issue in Georgia. In Georgia, a swing of 5% in penetration rates for the state can result, I think somebody told me, in $40 million. I mean, that's a lot of money. If you're just drawing down funds for which you are eligible by the department doing a good job of documenting things that they have to document. It's a big issue. Georgia's increased theirs considerably.
Do you know what rate Georgia receives their drawdown dollars? Because I talked to one of the administrators today, and he said in Nebraska it's only 30%.
I've heard 60 on foster care dollars. That's the term that the agency tosses out to us when we're talking about denying them the dollars through these findings. They say you're costing us 60% of foster care dollars. So I don't know. Even 30% is significant money in our system. All right, well, let's take time to look at the second scenario if you have not already done so. There are a lot of questions in this one, as you guys can see. The first issue we have is at the at the hearing, the mother's made a stipulation and the court orders the department to provide substance abuse treatment prior to having a pre-treatment assessment completed. And the department objects to that. I want to speak to that issue. The mom has admitted to a substance abuse problem. She stipulated, we made a finding, and they say they don't want to provide any services until they can get the assessment done. What would you do in your court? Let it go? All right. I don't think you guys are all that submissive. I got a feeling.
I would ask if the pretreatment assessment is going to be done by a KDAC or a LADAC, somebody with the qualifications to assess the treatment level needed. If it is, then I think that's the first step, and that's probably adequate. The problem I think lots of us experience is whatever PTA, whoever they have do it, a lot of times doesn't have any credentials to assess treatment issues, and they surprise, surprise, recommend after, 30 days later that she have a drug and alcohol evaluation by somebody qualified. So I would probably at least ask the questions is who's going to do the PTA? Do they have the credential to assess substance abuse treatment needs?
There were other hands over here.
Well, I was just going to suggest the same thing, that, it's not unreasonable to get at least some kind of an evaluation, assessment, whatever you want to call it, so that you know whether to order inpatient, outpatient, intensive, whatever. So, I don't think that the department is being unreasonable in asking for that. So I'd probably go along with them on that.
Okay. One question that we would ask, of course, I think would be, when is the assessment going to be done?
Yeah.
Now, if the assessment is going to be done in this week, and the appropriate service is provided after that, then that's one scenario. If they're not going to get it done for 45 days, then we really wait 45 days to begin working the case. Again, substance abuse, when we're required to meet ASFA guidelines, that is, move this child to permanency within 12 months, and you wait 45 to 60 days in the case to define the problem, as long as it takes to solve substance abuse problems, how are you going to solve it timely if you wait that long? So asking when they're going to do it. The quality is certainly important, because if they're going to contract the provider that's not qualified to do it, that's going to further delay permanency if we achieve it at all. And but the timeliness, I think, of it is important. When can they provide the service? And this is happening on a consistent basis. Then you have to ask the question is, why can't we do in your jurisdiction what we have done in ours in Troup County? And that is find a way to make certain these services available very, very quickly instead of delaying them.
I would think, and I don't know here what other people know about pre-treatment assessments. I'm not sure what a definition of a pre-treatment assessment is, but you better know what it is. And then if the whole thing is anything comparable to what is my experience used by our probation services to screen people, and then to follow up with an evaluation based on that, rather than waiting for them to come back to court. I order a drug alcohol evaluation. These are in criminal cases or whatever, and then I say you go through this assessment and then follow the directions of the provider of that assessment as to whether or not there is a need for a drug alcohol evaluation, rather than waiting for him to come back to court. That's a procedural thing I do in criminal cases. I don't think it should be any different in juvenile cases.
What I was going to say is, in our jurisdiction, we had a problem with that very thing. And following up on your approach with your stakeholders and your service providers, what we did under that circumstance, our equivalent of your Jobs and Family Services, their director and myself, we joined together and went to the mental health and drug and alcohol service providers as a joint effort and said, we're having this problem and these families just linger waiting for an assessment. What can we do as a team to expedite the assessments? And an arrangement is made, they do the assessments at the agency. So at the shelter care hearing, there's already been an assessment. So but that is an example of taking it one step further with your stakeholders. So we're not the bad guys.
Get it? Let's do this too. If anybody ever watches this thing afterwards, they don't want to see this Georgia boy. They want to see some of you guys. So if you all will, when you respond, if you will stand and look towards the camera up there. That may chill participation. I hope not.
I have to stand later.
Can you at least look that way?
Yeah, I'll look in that direction. One of the things that maybe we could use in working with the department in terms of getting the turnaround sooner is that my understanding at least is that when women have children removed from them, if they've been on Medicaid, they've got Medicaid coverage for a while, and our State Department does not want to pay for treatment if they can help it. So if we can get a recommendation for treatment and get these women into treatment soon, they've got at least Medicaid coverage for part of that, if not all of that treatment. And we wait, the last no reasonable efforts findings I made was the situation where the parent was willing to get treatment, and 90 days out, she'd lost her Medicaid now for the 2-year-old that was removed. They hadn't even made referrals for the level of treatment their evaluation suggested. So, it may be something we can work on with the department. It serves all of our, children more than anybody, but it serves all of our interests.
That's a good point too. We do want to access all other resources before we draw down the DFACS dollars or your agency dollars. However we go about doing that. If they're eligible for the service any other way, we need to try to get that done and save these very scarce dollars.
As I'm seeing this scenario, I see it drawn up to say, is the 90-day wait reasonable? They've got the assessment, they've recommended the treatment, they're saying, we aren't going to pay, and she can only get into the sliding scale 90 days down the road. And I think that's the issue that you're facing, whether a 90-day wait is reasonable, or do you start paying day one so we don't have that 90-day delay. Some of the things that all of us face in rural areas is there may be a 90-day delay anywhere, or what type of service are we going to be able to provide with the transportation issues, that the intensive outpatient program that's recommended, the closest one is 90 miles away. How do you assess and deal with those issues? And that's probably tier two reasonable effort issues.
I guess if you're in, and we have that problem in Winnebago a lot too, where if there really just is no availability, one of the questions I'd have is, well, are there other services, maybe less intense services, that you could provide until that space opens, and is that sufficient to address the issue until that 90-day bed is available, or is this a circumstance where this person needs the high level of care right away? I think that's a differentiation you need to make as well.
Those are all very good points. And the this ship may have already sailed. I don't know, but do you have a judges association?
Yes.
Yeah. Then, to the extent that these contracts are the contracts already signed with the service providers? No. To the extent that they're not already signed with these service providers, I would suggest that your judges association meet with the department and talk about making certain they build into these contracts reasonable efforts pieces, whether they're sliding scales into their contracts. If they're going to get the gravy, they've got to take some of the other stuff that goes with it, perhaps. And I think I mentioned yesterday, I know to some of you individually, that our new state director is starting this month meeting with service providers each month to try to do these kinds of things to ensure quality services are available to all of our families. And he's going to use the leverage of the checkbook to negotiate into these contracts with service providers these kinds of features to make certain we can serve the children. I think we're in agreement you can't just do nothing. And we can't wait for this assessment to be done to provide any services where the need for services are so obvious. Whether it's even just requiring her to do things like AA or NA or whatever it might be. We need to make certain the case manager has exhausted all other available resources like sliding scale providers and things like that before they just don't do anything and wait on a given service. I had a case manager a few months ago that used the word wait 6 times during his testimony, 6 times, in terms of trying to explain to me why things weren't done. He was waiting, used it 6 different times. Waiting is something we can't do. We can't wait. So what's the next question in this scenario now? We're into This is the 9-day waiting list is what we have. So we talked about the pre-treatment assessment, and now the 90-day waiting list. Any responses to that? So the 9-day wait list and the mother's attorney wanting to get the work done. He's trying to make the department.
Is this a pre-adjudication? Yeah, that's my question right now. Is this pre-adjudication or is she admitted to jurisdiction?
She is admitted to jurisdiction.
Okay,
She's
so
under
we do
stipulation.
have power to make orders.
Do have the power to make orders. You can certainly order mom to go in, but she wants to go in. She wants to go in today. Her lawyer wants to go in today. But the department says, well, we got to provide that we'll do it in 90 days. 90 days. Now, by the time we're at this hearing, I don't know where we are in the case. I don't know how many days we are in the case, you think, by this point. She makes them at the initial hearing, doesn't she? The stipulations in this case. So we're very early in the case, but if we wait 90 days, we're 90 days in the case now before she begins treatment. So what do we do? Does anybody order the department to provide it and say, take it up if you don't like it? If you don't provide it, I'm going to hold you in contempt? Somebody speak to that. Tell me how that works.
What's been happening in our jurisdiction is I think the parents' attorneys have kind of caught on to what's going on, and so they're asking the opportunity to present evidence at that first hearing about indigency and the parents' willingness to cooperate, and based on that, then I think we have a record upon which we can order the department to pay at that point. And they basically kind of acknowledge that, saying, well, if we're ordered to pay, we will pay. So.
We sometimes get excited about some of the weirdest things, and like we get excited when lawyers get it. And one of the most exciting days for me was post-ASFA when, during a hearing, the agency's attorney stood up and said, Judge, wouldn't this be a good case for concurrent planning? He got it. He understood it. And that certainly makes the system work better when you have lawyers that advocate for their clients on either side. It is an adversarial system to a point. But once you get past that point of adjudication, then everybody should be advocating for the same thing, services, to solve the problem. Someone else would find them in contempt, actually. If you would order them to provide the service short of 90 days, and if they fail to do it, how do you get to court? Does the parent's attorney file a motion for attachment for contempt? Is that how it happens? How would it get to your court?
Yeah, that would be the way to do it, but it would seem to me that it would be quicker, cheaper, and easier to just say, well, if you don't do it, then I'm not going to make the reasonable efforts finding, or make a finding there is no reasonable efforts, because you can do that like that, whereas the contempt thing is going to take probably a month to do.
One thing that a friend of mine, again, looked up a lot of Nebraska case law for me and policies and things like that. And one case I ran across that I just have the synopsis of suggests that there's no independent right, excuse me, created for the parents of the child to request a review of reasonable efforts. I don't know if any of you are familiar with that case. I just have the synopsis, but it certainly wouldn't stop you from, it does not prohibit you from reviewing the issue upon a lawyer's request. Whether or not it creates an independent right is a separate issue. But let's say in this particular case, you order it, they say they can't provide it, and or maybe you just order it and they don't provide it, and the lawyer wants a review of the agency providing the service. Would any of you review it on request of that lawyer? Just a simple request? Pretty much all of you would? Okay. That's great. And quite honestly, that's a better response than I get out of a lot of my Georgia judges. They just say they don't have time on the docket to spend 15, 30 minutes on this issue.
Well, this gets a little troubling in both of these scenarios, because if you even do a basic benefit cost analysis, the cost of the kids in foster care for 90 days just overwhelms the cost of even inpatient treatment. That I think I would ask the guardian ad litem to get those cost figures, to build a record so that when everybody appeals it, that the appellate court will be able to look, and they have to be a little sensitive to the legislature's HHS committee looking and saying, you mean they were trying to not spend several $1,000s by just spending these $100? I think we got to do a little bit of that too if we're going to make the case.
And it's great if you have lawyers doing it. It puts a judge in a tough position to try to lay that groundwork for it. So you really need lawyers that can do that for you.
I have a follow-up to that comment. That's a position that I've tried to make several occasions with the department that you're spending all this additional money, and not only on the foster care, but on the transportation and the visitation and the things that are delayed because the case doesn't move forward. And their response has been pretty much overwhelmingly, well, that comes from a different pot of money. The treatment money is from this pot, and those are other pots that they don't seem to have a concern with, and that isn't anything that I'm concerned with. But that seems to be their response to that. That we've even had just the separate juvenile court judges of Lancaster, Douglas, and Sarker. We all met with the governor, heads of HHS. We made these types of presentations and pitches and explanations, and unfortunately, nothing really came from that meeting that resulted in any changes. It's just been business as usual from the department since then. But that is a very valid point that I think needs to be further expanded on, that there are several other expenses that in many cases are well beyond. That's not to even considering the expense to the child being out of the home longer, or either the case resolving with the kids going home, or moving forward with an alternative plan if the parent doesn't cooperate with the services. But all of that is put on hold for that 90 days, so I would absolutely order them to pay for it and do it right away.
You know, and I would say generally too that you know, a lot of you guys are implementing some very good practices, and I commend you for that. But the more those practices become the norm and not the exception, the better case you're going to have as a state of establishing appropriate thresholds for reasonable efforts. Because if you're out there and you've really pushed for improvements in your system, in your individual county, and you make a no reasonable efforts finding, then the more likely it would be with my appellate courts to find that no, that's beyond reasonable. That goes way beyond that. I mean, nobody else in the state is doing that, so we can't expect this department to do it, no matter how good a work you've done off the bench to develop those resources. So what you do or don't do in your individual counties ultimately can affect the outcome of these decisions when they go up. I would hope that with the focus on reasonable efforts, not just in my presentation, but all these others, there are 4 or 5 presentations on reasonable efforts, and particularly with this change in your infrastructure out here for services that's taking place, that one of 2 things will happen. And one is you're going to get an improvement in the delivery of services, better services, more timely for your families, or you're going to get more no reasonable efforts findings. One of the 2 things really should happen with this emphasis on providing services early on in the system. If you focus on doing that, you've either got to improve the system or you've got to find that you're not doing the job, one way or the other, I think.
One other thing, I don't know if others have heard this too. At that meeting I told you about, they are also distinguishing these contract providers that they are doing services, but Magellan will do treatment. And so I asked, would you please, again, 80% of our cases are mental health substance abuse. Would you tell me what difference that makes? Well, that's your HMO, Medicaid and et cetera. So how this parses out will be interesting in all those respects.
Again, I would want you guys to, have a voice in the development of this system out there, because you're going to be making decisions. It would almost be unfair to let the department go out there on its own and build this new system, and then you guys start making reasonable efforts findings suggesting that it is not meeting the minimum requirements of the law. So I think it's better to deal with it up front. And also, once the contracts are signed, they're signed. There's not a lot you can do about it.
A comment. I got supervisors and case managers that frankly get these things done almost always. I rarely have this problem. And I think there's maybe a systemic problem in the department, because I've got really good supervisors that see to it they get done, and I don't get these arguments that say we can't get it done. I'll sit there in court at the very first hearing and say to a case manager, can you get this done and do this, this, and this? And she says yes. So it seems to me that part of the problem is who you're actually physically dealing with, and that perhaps the people in Omaha, for instance, or Lincoln are not willing to work with the judges like my experience is.
Anybody want to speak to that? That's a good point. At a minimum, what you can do when you're confronted with this, what I would say the minimum is you simply state to the case manager that's present in court, supervisor, whoever is present, that is just not acceptable. Just not acceptable. And I'm going to give you 20 days or 15 days to come back with a better solution and schedule the case for a review. And if they don't either come back and have solved the problem, or can I convince you that they can't solve the problem in spite of the exercise of reasonable efforts, then you make the finding. But just, I use the word I like to use, and you may have others more descriptive, is just not acceptable.
A quick follow-up comment. The one time that I had this major problem, we literally went 6 months and they didn't do anything, was a caseworker out of Lincoln, not out of my own district.
That would be you.
No. I understand that they have a different mind frame up there as far as some of their HHS people, and I don't experience that very often. Except when the interlopers come in from out of my district.
Maybe we can trade.
That would be a good time to move to scenario number 3. I think we worked on number 2 pretty good.
Judge. One other comment to the Lincoln judges. When I'm sitting in Sling County, the providers that they're using are the same people that you provide, or use as providers too. So I'm not sure why the people in Lincoln have a problem when the people in Beatrice and Crete and places like that don't have a problem.
You guys should sit together at lunch today and talk about that. Maybe y'all can figure it out. Number 3 looks kind of familiar to me. And, we have a mother here who came in early, wanted to make an admission, provided that she could enter into substance abuse treatment. Caseworker once again says, nah, till we get the PTA, we're not. The court goes along with that a little bit, orders them to offer it and sets a hearing 30 days out. You come back to the hearing, find out the mother was not even contacted to set it up until 14 days after the protective custody hearing, and that the PTA provider was not contacted 28 days after the protective custody hearing, so 2 days before the review hearing. What do you do? What do you want to do at that hearing?
This is the pretrial hearing?
Well, when it says pretrial, I think it's that hearing the judge scheduled 30 days out to come back and address that issue. And if supposedly if you're at that issue, the PTA was done and suggests that this treatment's needed, and the cert agent will provide it, the mom will stipulate, you adjudicate, she goes into treatment. That's the way I read it. So you're sitting there now and you can't do much of anything, can you? The mom's not going to stipulate still probably unless she knows she can get treatment. You can't get treatment until you have the PTA. The PTA was, I guess, not scheduled yet because the provider wasn't contacted until 2 days ago. What do you do? After you break your pencil, slam it down on the bench. I don't know. Do you force the case to trial, assuming everybody's ready for trial at that point? You don't accept mom's not going to make her stipulations. Say, well, fine, let's just try the case then. Do you do that? What do you do? I mean, does this ever happen? Let's talk about generally. I mean, we come to court and we can't conduct the business because the agency has not done what it's supposed to do.
I was going to say, the thing about the scenario that doesn't ring true to me is I've never had anybody say, I'll admit if you guarantee me treatment. I mean, they just come in and admit. And it isn't contingent upon treatment being immediately available.
There's another difference too. We would, I'm not sure, I'm like Jack, I'm not sure I understand what you mean by a pre-treatment assessment. If we had a mom come in with a meth problem and she admitted, she'd go directly to St. Francis Hospital for a drug and alcohol evaluation. Okay, and we would have that, it would be readily available, we'd have it in a couple of weeks, and we'd know from that drug and alcohol evaluation what was recommended.
Okay, let's use that term. It doesn't matter what we call it, because I think that's what we're talking about. The agency's not going to pay for mom to go into treatment. I'm not talking about self-help. I'm talking about treatment. So they've had some professional evaluate mom and say you need it at that level. So let's say that's what we're talking about now. and we don't have a system like yours where you can get that done in 2 weeks. So you're at the initial hearing, and let's even forget the part about mom, because I don't think that's the real point anyway. Mom is willing to stipulate, but the department says we can't provide the services until we get it. It's kind of a follow-up on the previous scenario. You say, okay, fine, I'm going to give you 30 days to get that done. We're coming back in 30 days, taking a look at it. We get back in 30 days. 2 days ago, they called to try to schedule this thing. What do you do now? Two hands over here, so let's get.
Well, I think that's the lack of effort, and the thing that we talked about, that during those first 30 days, you can't just say, go and take care of this. They need to schedule the assessment. They need to let that mother know this is the day you have to be here. Do you need help with transportation? Make sure that they've been given every opportunity to success and comply. Here, they just said, I thought there was something, maybe this was in the last one, where they just told them, go get it. And the other thing here, then, they waited until the 11th hour to get anything done. And then we're seeing some of the consequences of that 90-day delay, waiting for that sliding scale bed to open up or whatever, is that we had a motivated person, at this point, 90 days, 120 days down the road, they've got frustrated with the system, and we've lost that advantage.
Well, and I mean, if you're at your 30-day out and you realize, you're at your 30-day out hearing and you realize that it happened at the 28th day, I think at that point, you entertain telling them to come back in a week and give you a more very detailed plan. Obviously, at the first hearing, you assumed that the caseworker was going to get everything done that needed to get done. That hasn't happened. So then you just, at that 30-day hearing, you tell them to come back in a week with a detailed plan of how this is going to happen, what kind of services are going to be provided until that happens. Just so, if you get to a point where the department's shown that they're not going to be able to do it on their own, then you make them come back and give you a lot more detailed plan to make sure it happens.
Let me ask you guys what, this may be a place you guys don't want to go. What could you have done at the initial hearing to have made things turn out better? I know you don't want to be a case manager, but what could you have done?
Doesn't this kind of come back to that issue that you talked about yesterday with getting the stakeholders involved? Because I just wrote in my notes getting our provider to come to our stakeholder meetings, because this is an issue that comes up all the time for everybody, not getting that initial assessment or evaluation done because they can't get them in, because we have a 30-day, 45-day waiting list. So that comes up all the time. This is more of an issue of, even before this case happens, getting the department to realize this happens all the time, the stakeholders realize it happens all the time, and do something about it pre-new case.
It's a good comment. Let me say this on the way back. I sat for another judge in an adjoining county recently, a very small county, even compared to mine, and I was shocked. And we're going to talk about this at our next quarterly stakeholder meeting too. As I'm sitting there and I'm trying deprivation cases, we call them, I look in the jury box and wonder who these people are. And this is a judge who was a little ahead of his time, and we're going to have open courts starting in January. He's always had open courts, so people in the court, they allow people in the courtroom over there that we wouldn't allow. So, but they were in the jury box, so I wondered about it. So I called the lawyer up and said, "Who are those people in the jury box?" He said, "Oh, they're the service providers." I said, "They're the what?" "They're the service providers." So here was the local mental health units that provides all the services to the juvenile court, sitting in the jury box, waiting for some work. I mean, to give us reports or waiting on work. If I order something, it's done then. Pretty cool.
When that meeting that Reggie mentioned with the governor last January or whenever it was, we talked about these issues. And as I understand it, the pre-treatment assessment is one piece. There's the mental status eval is another piece, and that's all Magellan-driven to lead to a full substance eval, a full psychological, then a psychiatric if that's indicated. And you got to go through their hoops according to their policy. I don't know that we have to follow that, but there are many courts. L.A., Mike Nash got this going with a huge dependency system, and other courts throughout the country. And I think Toledo, you have a duly credentialed clinician, and you go from the pre-hearing conference, and again, it's voluntary, no admission against interest, you get the eval done at court. Just like people will send probationers, go see the probation officer. You do it right there because you need a safe harbor that's timely and accessible, kind of like a domestic violence case. Restraining order gets you what? You need to get to the victims program. And so if we could work as a group figuring out distance issues for courts that hit many counties, figure out the mobility issue, we would save so much time, like Pat says, with foster days, closing our cases, getting kids home sooner, and it's 80% of the work we're doing. And so to me, it would be a great conversation, and I've talked with Kelly about piloting that, and I don't know if the department's willing to do that, but it would work, and it's working in other courts, and we can show that to them. It saves dollars, and it's effective.
Let me tell you one other quick thing that you could do about it. This is where I said you guys may not want to go, but I don't know why you wouldn't. It just takes a minute. Is what's wrong at the preliminary hearing with directing the case manager to go outside and call the provider and schedule the assessment? What's wrong with that? And you actually put it in your order that mom's to appear at that date certain to have it done. Now I teach that as part of our case planning. Is what I tell them to do, because we're required to develop the case plan with the parents' participation. While you're at the table preparing the case plan, call the provider and schedule the appointment, put it in your case plan, the specific date, time, and place. And it saves you a lot of work. Again, that's something you got to do after mom leaves anyway, whether it's that day, next day, or the next week. It's something you got to do anyway. It doesn't take any more time than it will. It probably takes less time than to try to do it later on. Additionally, if you wait until later on, then you got to try to find mom to let her know when the appointment is, and that's not always easy. Not always easy at all. So do it while they're there, and there's no reason we shouldn't do the same thing. We do it with our family team meetings at our emergency hearing. I require those to be scheduled at the preliminary hearing and put the date and time in the order.
This is just a question, but it occurred to me that probation is doing chemical dependency assessments all the time as part of PSIs. Now, this is something that is not probation's job, but if we could convince the chief, which seems to be pretty on board with this whole thing, even those of us in the hinterlands have access to a probation officer, and maybe, we could get an assessment done in a week through probation.
We've also trying to use new technology, and if you don't have a probation officer sitting there, they have this little device known as Skype, and most of the interview could be done over Skype, and they could come up with a recommendation there. Right on the spot. If you have the equipment there, you can connect up with somebody and do that assessment through the probation system, or using something akin to the probation system, it's done. Now, there's some questions here, Bob, know more about it. We're dealing with this issue right now, communication in our district.
But you're still stuck with the same funding issue. The ones we put on probation are referred to parties, they're responsible for getting it paid for, and starting out, this parent isn't going to be able to pay for it. You're stuck with the same kinds of issues. How much luck have you had with ordering, saying, okay, the pre-treatment assessment's got to be completed within 14 days, you'll implement the plan, and you'll also come up with a plan for supportive services until the other goes into effect, like NAAA, any other support groups you've got to keep this person afloat until you get all of the professionals on board. What's been the approach there?
I want to speak to that from a Nebraska perspective. Let me just say from the judge's perspective is that no matter how I personally feel about it, I can't print money for the department, and I realize that there are limitations. But it is my responsibility to make sure that we've exhausted all resources before I allow services not to be provided without making no reasonable efforts finding. Scenario you talked about, then that's kind of what we do is we set expectations that those kinds of services will be delivered. If they're not delivered, they got to show cause why they weren't delivered. They got to convince me they really don't have the money to do it. And even then, if it's reasonable, and I think they've given a good shot, I may defer the decision for up to 30 days to give them one more opportunity to try to find resources.
I have to make a comment. There's one other thing that we don't seem to discuss here, and it's not applicable to Omaha or Lincoln or Sarpy County, but the rest of us who cover, like in my situation, 3 counties, when we talk about we'll do this next week, or we'll do it in 30 days, or we'll do it in 60 days, my calendar doesn't allow that. I don't have the time. 2% of my cases numerically are juvenile cases. They take about 20% of our time. But when you flip your calendar open to try to figure out when your next hearing is going to be, for instance, in Saline County, there isn't a 30-minute slot for 6 weeks. I know Jack has that problem in Adams County. You know, and trust me, we've set hearings for 5 o'clock, 5:15. We even did them on Saturday, which really made the department happy about that. But we have that logistical problem too, that I'm covering 3 counties in 5 days a week. In 1 county, I'm only there 3 days a month. And to try to keep these things moving as quickly as everybody wants us to keep them moving, sometimes is just not possible with the way our calendars are.
And I know I can't possibly speak to that with any authority without, spending more time with you, visiting your court, looking at what you've got. And I also don't share with you all these other jurisdictions that you have, the other areas of jurisdictions that you have. But I can tell you there's not a problem that can't be solved if we work hard enough at it. And you took away my one suggestion that I had right off the bat, and that was the Saturday morning 8 o'clock hearings. And I scheduled one time at 8 o'clock on the Friday after Thanksgiving. And the problem was solved, before Thanksgiving. And there are ways to do it, but ultimately, we've got to just piece at a time, put better practices in place, raise expectations, and work together to do that. And over time, our caseloads are going to come down. Now, that's one thing I can tell you. You heard the numbers this morning. Our caseloads are down, so I have more time on my docket than I had 3 years ago.
Yeah, see, I'm in a situation where I schedule criminal trials and try to guess which one's going to go. And I literally know my attorneys well enough that I may have a DWI trial that's going to be a 2 or 3 hour trial that I allow 15 minutes for because I'm planning on them pleading the case. And fortunately, it usually happens that way.
But the answer ultimately is to do better front-end work and reduce the caseloads. That's the answer ultimately. Then I'm serious when I say I have concerns in my court about the state want to take case managers away and my county want to take people away because we've reduced numbers, but we've done it through hard work.
That's another thing, though, Michael. Some years ago, and I think it was at the impetus of the Department of Health and Human Services, we went from a system where HHS would go out, do the investigation and pull the kid, to law enforcement goes out and makes the investigation and pulls the kid in most situations. And I think part of it was motivated by the fact that they didn't want the parents to hate HHS and say, oh, you're the one that took my kids and stuff. So they kind of insulated themselves. But the big problem is that when you let law enforcement make that decision, it's almost impossible to have reasonable efforts prior to that night that they're out there talking to the mother with the rats running around and the dirty homes and stuff like that, because nobody else has been in contact with that poor person to try to help.
We're about out of time, so I'm going to give open mic for maybe 2 comments or all questions.
You're right on that, and part of it, and maybe for some of the larger areas or sparse, it doesn't work, but I know Linnea Maestrick went from our jurisdiction to Sarpy, and she just told me, for example, some of the communication she's had, law enforcement calls her about a family on an issue. She's able to give some consult. They never did the affidavit removal. And she's telling me how she's working some things. And I'm thinking, I don't know how you do that in Omaha, but the concept applies if you could get them together somehow.
Just open questions, comments. Yes, sir.
Okay, this is kind of something completely different. Is there a definition of home? I mean, usually we're able to figure that out, but 2 scenarios fairly common. The kid has been with someone other than a parent at the parent's own wish for months. Okay, it's removed. The child is removed. Is the child back home if you put him back with a non-relative, or is the child back home if you got to put him back with a parent? Second thing, the mom is 15 years old. The mom's put in foster care. You put the kid with a mom, it would seem to me the kid is home, but no, they say because the mom's in foster care, the kid's not home. So is there a definition of home anywhere?
I want to speak to that generally from Nebraska. In Georgia, when we were, I can't say in my court, when we remove a child from a home, we consider that to be the home from which the child was removed. And if the child's been there for a period of time, that's why we would try to stabilize the home. Not a situation where mom dropped the child off 2 months ago and never came back. I'm talking about the child has been there, particularly if it's a relative, for an extended period of time. We treat that as the home. And yes, when we have teen moms who are removed from their homes, we try to keep the teen mom and her child together. We make great efforts to do that. And we're blessed to have a facility, Second Chance Home in our community that allows us to do that. Last comment.
One of the keys, I think, to making the judicial system work is the attorneys. And I don't know that you have that in Omaha and Lincoln. But outstate where we are, we have a different culture. And it's more of an adversarial culture. So what I've tried to do is ask nicely for my attorneys to attend as many of the seminars as possible. And I brought a slew of them. I tried to bring 15 or 16 of them down here today, and I had to cut back. But you can just see their eyes being open when they hear the things about reasonable efforts. And Judge Johnson is going around the state and putting on that Helping Babies from the Bench, which I thought was terrific. Now, I don't know if you can still do it, but I had talked to you earlier about coming out to my district. I can get as many attorneys there as possible. That opens their eyes and it changes their culture on being non-adversarial, and that's a big key for me. So lean on your attorneys nicely and get them to all that education, and that'll really help us.
All right, I want to thank you for your attention. I hope your attention this morning, and certainly your participation in yesterday's workshop and today. It's been absolutely wonderful. I hope that I have not stepped on too many toes or created too many problems for you. Thank you for having me out.